All right. Before we get started, Mr. Winder, I want to make sure you understand our process. It's my understanding you're not an attorney, is that correct?
Yes, sir. I'm
Okay.
a pro se attorney.
Okay, you understand, you've sat through some of this, you've seen the process that we follow.
Yes, sir, Your Honor. I
Okay,
did.
do you have any questions about anything you don't understand?
No, sir.
All right, in just a moment, when we start, I'm going to ask you to give us your name, and at that point in time, the light will come on and you can begin to make your argument, tell us whatever it is you want to tell us about this.
Yes, sir.
Do you want any rebuttal time?
Yes, sir. I'd like to remain 5 minutes for rebuttal.
5 minutes, all right, sir.
Yes, sir.
Okay, so what will happen is, after you introduced yourself and the light comes on, you'll have 10 minutes to tell us whatever you need to tell us. Then you can sit down and opposing counsel will make his argument, and then you can come back and have 5 minutes of rebuttal.
Yes, sir.
Okay, no questions?
I'm good. Yes, sir.
Okay, are you ready to go then?
Yes, sir.
All right. If
Good
you'll
afternoon,
tell,
Your Honor.
yes, sir, if you'll just tell us who you are.
My name is John A. Weiner. I'm representing myself as a pro se attorney. I'm not a lawyer, so I'm representing myself in this case.
All right, sir.
This case filed on December 23rd, December 27, 2023 is based on defamation of character. The complaint was mailed to all defendants, making them aware of the appellant's attempt to serve process. This case was dismissed based on insufficiency of process and the insufficiency of process service. The trial court dismissed the complaint under the civil proceeding rule 12.02 was procedurally flawed and improperly granted. By failing to exclude rule 12.02 parenthesis 6 from the motion to dismiss, the court distinguished and required that rule 56 deprive the appellant of a fair opportunity to present relevant material. The misapplication of the procedural rules resulted in the missteps and a lot of errors and should be warranted reverse. Additionally, the trial court failed to recognize the appellant's valid attempt to serve process, including permanent filings of the summons and returns consequential motions to amend. Under Rule 4.09, the court had dissension allowed amendments unless it resulted in materials prejudicial to the opposite party. Yet it did not exercise this appropriately. The trial court further neglected to address service of publication. Despite multiple failed attempts to Kenneth and Keisha Woods by not giving them fair compliance to the service required. As established in Merrimack versus Regional Mortgage King and Southern Contractors of Lowry County Board of Education, appellate review such procedural rulings is conducted under pure due standards with no deference to the trial court conclusion of law. Under this standard, the trial court failed to follow Rule 56, warrants reversal. The appellate reliance on Tennessee Rule 12.02 parenthesis 6 as part of their motion to dismiss mandates a different procedure treatment than what was afforded by the trial court. Rule 12.06 parenthesis 6 specifically governs motion to dismiss for failure to state a claim upon which relief was granted. Critically, the rule provides if on motion of cessation defense under number 6 to dismiss a failure to state a claim upon which relief will be granted, matters outside the pleading presented to and included by the court, the motion shall be treated as one of summary judgment and disposed of provided in Rule 56. In this case, both motions to dismiss the Rule 12.02, parentheses 6, and the trial courts considering matter outside the pleading, namely affidavits, green cards, and other documents. These materials were not included. Therefore, the court was procedurally obligated to treat the motion as one of Rule 56. Misappropriation of the appellate mischaracterization. Appellate attempt to sidestep this issue by crying Roberts on behalf of Edwards and Hardy, arguing that the court may consider outside pleading of Rule 12.02, parentheses 4 and 5 motion, without converting them to summary judgment. That may be true for adjudication defense like insufficient process or insufficient service. However, Rule 12.02, parentheses 6 invokes evidence is considered. This conversion of Rule 56 is mandated and not disagreed upon. The appellate cannot have it both ways. They cannot rely on Rule 12.06, parentheses 6, and submit outside evidence, then avoid proceeding consequence on Rule 56. The trial court failed to properly include Rule 12.02, parentheses 6 from the ruling. Reverse should happen. Relying on the court's ordering dismissal rule of 12.02.6, the trial court ordered granting all states company motion to dismiss under Rule 12.02, parentheses 4 and 5 is procedurally flawed and unsupported. The court's reasoning that the original complaint was mailed without the summons and consequently failed to comply with Rule 4.05, parentheses 3. Critical facts in the record and missteps in the governing rule. Failure to comply with Rule 4.09 and Rule 56. The trial court failed to address the Tennessee Rule Proceeding 4.05, which provided an amendment to the summons shall be back the date originally issued. And if the defendant is not prejudiced, Mr. Winder resurface of the summons accomplished by certified mail to L. Chevier, who checked that he was a qualified agent to comply. The record confirms all states received summons and the complaint. The trial court did not make any findings prejudice all states that did not explain the Rule 4.09 was inappropriate, was inapplicable or inappropriate. Moreover, the trial court decision to treat all states Rule 12.0206 motion moot procedurally improperly once that if this happened, introduced the evidence, the court was required to treat the motion under Rule 56, as stated in Mary C. Smith versus USA of Lakeside Incorporated. Trial court must comply with Rule 56.04 by providing a clear statement, a legal grounds when disposing of summary judgments in motion. The trial court failed to do so, depriving Mr. Winder of his 30-day response for the opportunity to present evidence. Procedural errors in the trial courts occurred for this motion dismiss. Procedure support proper appliance, the proper appliance that Rule 56 was not followed. Challenge the dismiss of this complaint with prejudice. It should not have been done with prejudice because at no time that the facts of the case were even stated. Procedural errors and service of process. The appellate did serve the summons on Daniel Lofton, returning it on February 21st, 2024. In an effort to notify the court promptly, the appellate permanently filed a return summons. However, Lofton received the summons on February 29, 2024, prior to the March 11, 2024.
Excuse me, sir. How was Mr. Lofton served?
He was served by process served by certified mail with a green card stand, and he signed it. His law partner signed it. Daniel Craig signed it and sent it back to us.
Okay, so Mr. Lofton didn't sign it?
Mr. Lofton, Daniel Craig, his law partner, signed it.
Okay,
Mr. Lofton signed the first one, but his law partner signed the second one.
and did Mr. Craig file anything in this matter?
No, sir, Mr. Craig did not file anything in this matter.
Okay. All right, go right ahead.
Okay. In an effort to notify the court promptly, the appellant promptly filed and returned the summons. However, Lofton now received the summons in February 2029. And recognizing the errors in the summons, the appellant filed a motion to amend the summons. On March 25th, 2024, the appellant filed a motion of objection and requested that the court correct the records, and then it was done. And that's it.
Okay. You still got your rebuttal time, sir.
Yes, sir.
Hear from the appellate.
May it please the court, I'm Jay McLemore from Williamson County Bar, first time in the Western section, so it's good to see y'all.
Welcome.
This case is, from my perspective, I represent Allstate, fairly straightforward here. The original, we have two grounds.
Let me make sure of one thing. You're not representing Mr. Lofton, right?
No, Your Honor. I
Okay.
don't think they even filed a response brief or anything. I'm just here for Allstate.
Yeah, okay, and so that also includes the Woods?
Yes, Your Honor. I don't believe service was ever achieved on the Woods from what I can tell for this particular lawsuit. Yes, Your
All
Honor.
right, go right ahead.
So the Judge McCraw from the 25th Judicial Circuit, his order was correct. This was dismissed under Rule 12.024 and 5 for insufficient process and insufficient service of process. When it comes to 12024, the process was the process was insufficient in the sense that Mr. Winder's pro se did not include some of the basics, that is his name and address. You have to have that as a plaintiff's attorney or the plaintiff if you proceed pro se. The other problem, Your Honors, is he failed to even serve the summons with the original complaint. So there was a complaint that was mailed, and I'll get to that for insufficiency of process, without a summons. So that on its face, as per the cases that I've cited, the Iman case versus the Kentucky insurance for Turkey farmers, it doesn't have any effect of law if you serve a complaint with no summons. So Mr. Winder then went back, got a summons issued after he mailed the complaint in December. However, that summons, he went ahead and marked it as completed and returned on February 21st of 2024, when he actually didn't mail the complaint with the summons until March. So, I'm sorry, February 27th. So the complaint was already mailed with an executed return summons. Again, by mistake, I know Mr. Winder was trying to comply. However, that is problematic under insufficiency of process. Then we get service of process arguments. Simply put, Rule 4.053, if you're an out-of-state corporation, even if you're licensed here, you have to serve the registered agent. You cannot mail a complaint to the company and say, hey, you're served. So the registered agent has to be served as per rule. It is clear in the record, the summons was just addressed to Allstate. Mr. Winder is correct that a green card was returned signed by an individual named L. Stave, but the green card does not make him the registered agent. So the registered agent was never served. Mr. Winder then tried to take a $100 million default, and we moved to dismiss the case. Because the process was insufficient, Judge McCraw granted our motion to dismiss. The motion to dismiss for failure to state a claim, Your Honors, was rendered moot because we never got that far because service was ineffective as per Mr. Winder's attempts to serve Allstate. And that, in effect, really concludes my argument. I believe this is, unfortunately, the rules are here. They have to be followed. and these were just not followed here very clearly by Mr. Winder, and that affects the service both under the process itself and the service of process, and so Judge McCraw should be upheld. Y'all have any further questions? If not, that's my argument.
Thank you.
Y'all.
Mr. Winder?
Yes. We want to clear the record. The summons was served in February without,
Now, which summons are you talking about?
there was 2 summons served.
Right.
The-
You're talking about the all-state summons?
The all-state summons.
Okay.
The all-state summons was served with, the lawsuit was served without a summons in January. Then, once we realized a mistake had occurred, we filed a motion. We amended it, went through the amendment process, and we served a second summons. The second summons was served on Allstate Insurance on February the 27th. El Chavro checked the box that he was the qualified agent. Now, Allstate had every opportunity to come to the court today, Your Honor, and say that this was not the qualified agent. There is no evidence that Allstate said this was not the qualified agent. Allstate have 6,000 employees in their Naperville headquarters. We don't know what this is a qualified agent or not, but he checked the box. Now, the same El Salvador person, they signed the first green card that they got to complain. Then they signed the second one, the same person signed, but on the second one, they checked the green box that they were legitimate, a qualified agent. And we don't have a copy of all states' employees to know who's a qualified agent and who's not a qualified agent. So the court, we have to go by, in my opinion, what we have in writing, and he signed it. He checked the box on Allstate. Then Allstate said that we never served the summons. That's incorrect. In their dismissal, that we never served the summons. That's incorrect. We did serve the summons. We served on the proper person. We got the green card certified to return that they got it, and we have to go along that that's the correct person. The trial court judge erred in a lot of cases, and there a lot of missteps. Number one, failure to apply Rule 4.09 to validate an amended service. Number two, ignoring Rule 56 procedure required after considering matters outside the pleading. Number three, misapplying Rule 4.05 parentheses 3, despite evidence of the agent's receipt. Declaring Rule 12.02 parentheses 6 moot without proper conversation or analysis. Number five, the trial court judge entered the same order twice, once on April 1st, once on April 26th, one with prejudice, one without prejudice. It just amazes me how, and they was identical wording. Number six, failing to assess whether the 90-day rule, they didn't allow me to do the 90-day rule. The 90-day rule should have applied here. The judge erred and didn't allow that to happen, even though I filed an amendment and a motion asking for that. Neglecting proper documents in the manner and receipt of service. Issuing a dismissal order without ensuring the procedure complied. An abuse of the censor code when the judge ruling based on a misinterpretation of the law or clearly erroneous assess of the law. The appellate explained that whether the trial court judge were oblivious, unjustified, or inconsistent with the fairness of the justice principle. Judge J. Weber McGraw issued an order dismissing my case, then said the summons never was served. He got that in his order. That's incorrect. The summons was served. And I got the green card to approve it. Daniel Lofton filed a motion to dismiss on behalf of the Woods. The Woods was never properly served. How can you dismiss a case that's not properly served when the merits of the case never was heard? Justification of the statement of this matter before this court. Final order, the Circuit Court of Fayette County pursued the Tennessee rule. Accordingly, appellant respect requests that this court reverse the trial court's dismissal, and remand for proper certification under Rule 56 with full consideration and service of the record and procedurally safeguards. And this is something that happened, and the trial, they were served properly. And the evidence is there because we got the green cards to prove that we did serve them properly. Thank you, Your Honor.
Thank you, sir. Gentlemen, what we'll do is take this matter under advisement. We appreciate your briefs, your argument, and we will attempt to render your opinion as quickly as possible. Thank you. You may be excused.